there's a tension there. But, and a lot of you are much younger than me. Where do you want to live? Do you want to live in a really active urban condominium and walk downstairs to the coffee shop?
Yes.
When I have kids,
Wait, just a second, yeah.
when I have kids, I don't want like people all in front of my house and like walking in the area because you might have pedophiles and all kinds of things. But right now, just for being young sake, yeah.
As a single guy, you want the urban village, but
Yeah.
when it's time for a family, you want suburbia?
Yep.
I want the chicken to wake me up.
I don't.
Rooster.
The rooster.
Hang on just a second. A rezoning, a PDD is a rezoning. Yeah. Wonder which, I'm trying to think, which of my presentations we get into the criteria for rezoning. Give me a second here.
The chickens make their own sound. They go clock, 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 clock. They're gonna lay eggs.
Let me hear a rooster now. Rooster. Let me hear
Are you finished with them?
Yeah, the next batch will get more into the rezoning process and the standards on that. But a PDD does require a rezoning, generally. Now, I wanted to, do you want to take 10 minutes now?
Yeah.
Okay, 10 minutes it is.
breakdown.
Yeah.
Y'all putting the ball towards your mental. You gotta like decide with there's meetings coming up.
Oh, great.
You gotta write some goals. There's a whole pamphlet they gave out at the orientation.
Oh, yeah.
How's the business going?
But my question becomes, is
You're
our
getting
choice
stuff from this experiment?
out of the board? Like there's 12 board members from Terry Stiles.
This has nothing to do with the land use. This is just the land use for tax appraisal. They have their own set of categories that they use for appraisal. So this is, I mean, as far as I know, and again, I don't know my data as well as I could.
Well, just give me any one of your
See
assistants
this,
will be fine. Can you give me any?
Yeah.
assessment. I don't know if that has anything to do with comprehensive plan land use, you know, master, what do they call it, Miami-Dade master plan.
I mean, I think you're supposed to
I
allow.
don't know if this is associated with it or not. I would tend to
If
think
you
that
want
it's
to go
really
to
only about the
issues,
appraisal
you multifamily
purposes of appraisal.
or office, you should go to Terry if you want to go office.
Yes.
And this is key to scheme.
One
Well, and they have it,
He's
I
on
mean,
the
the
national
village,
team.
they probably have their own plan, right?
Yeah.
It's all right. I ain't gonna write this.
Right.
Stay focused on
Especially what they give us the back, how it's a business. And then the business. What's that? Wait, you're gonna be forward. Design.
To mitigate the impact on the.
And then, because they, first one has to, like 400 something residents. And it's not a hotel.
Wow.
And yeah, it was massive. And there's some things that I can actually look for where, because there was a deal between the developer and the owner. So it says something like, you don't see on the property appraisal, the price of the land, it says something strange, like, not exposed to open market because motivation.
See, and again, that's a standard, that's a judgment call that an appraiser would make. It disregarding a comp for the purpose of valuation of other property. That's under their.
This is the first time I see this.
Where it was.
So probably the village, you know, the town or the village itself, you're gonna need to find their future land use map. And you're gonna need to get it from them as opposed to everybody.
One thing I tell you,
Working is
for
some
sure,
very
it's
exciting
triggered
stuff.
Yeah.
because of it.
I mean, that's, like I said, if there was a rezoning proposed at some point that generated an analysis of the rezoning criteria, that's fine. Again, it's the purpose of this is to expose yourself to how rezoning is analyzed.
How would the, that's not a just posted a lot of stuff.
No, it's not rezoning. It's the change to
Some reports, access to the
redrawing of the land. Yeah.
so they gave us.
I mean, others, some jurisdictions use it.
Got some more fruit here?
They put on plastic.
Yeah, they put a whole bunch. I'll let you know.
Okay.
That's in the other class.
Tenemos que encontrar si hay un.
I haven't seen that.
Yeah, it just came.
Delimitation and this still have.
Maybe.
I think it's intended to use with a project.
Yeah, it
They
is.
don't trust us to go back in.
Yeah, he's supporting us the data.
I didn't even go in.
I didn't.
I didn't log in.
I wish you would have said that.
I spent
it cost.
1,300. Well, they should have kind of
44.
specified.
I was like, oh, but when I did 44, I only opened like 8 reports, and then every report had a section I clicked, so it had like the marketing and everything in it. So I did like 8 different ones, and I just pulled out multiples for each one. But when he wrote me that email, I was like,
Very
you never
nice.
told us why. Can't do that. Like, can't use it.
Yeah.
He said in Broward County, West Palm, and those 3 locations you can use. And then, but then he said the other website, like he's like, oh, you can only use this one for
They forgot to tell us it costs money.
yeah, the most important part.
They say what triggers, you know, them getting an invoice.
Did he ever say that they actually got charged, or if they said it was
They'll negotiate.
Because on all of mine, it was the same exact thing that I was hitting the report, and then like I didn't know it saved it, and I went back and like looked at it again.
And they're gonna mention that it's talking.
I was trying so hard to remember.
We have all.
Oh yeah.
Young enough to work for the traditional.
I was.
learning skills, form relationships.
Harder to
On the side, whatever we can. The guy who did my favorite developer, John McNamara. He's an attorney, and he shows how they are
Professor. Exactly.
John M-C-N-E-L-L-I-S. And he's an instructor, he's building the ULI, Urban Learning Institute, but he's a kid John. their homes.
I hadn't had one for so long. I gave up on it. Yeah, so.
And he, at the time, is outstanding.
It's like a developer. You were trying to take a real estate.
Yeah, exactly.
What level did you get to? I don't know. I think it's not really 48. But I did it for a while. Like some people's are
I didn't see the assignment.
Yeah,
Just send data.
it's just the reason.
Just data.
Yeah,
Yeah.
that's how it's set up. How much more?
Oh.
Each?
Oh,
Birthday wishes for the other child. Are we all back? Ready to jump back in? Or is my voice
Yeah. Yeah, well.
On everything? That's not, that takes the fun out of it.
While we're waiting for a couple more people to come back, are there any questions about case studies? Are you guys making good progress on your case studies?
Can we do it on property that I'm working on it, a new one?
Oh, I thought you guys had already picked your case study. No?
Oh, you
Oh,
just
no, I'm
looked at
talking
your
about the
type of
project.
Oh, your research paper. Your research paper? Yep, again, it's really broad. It is any topic related to land use. Any topic related to the class.
As it pertains to being a research paper, do you want it like how research papers are like abstract and they go into like different details?
I would welcome that. It does not have to specifically be that format. If you cite your sources, and then if the paper is more similar to a really engaging article on the topic, that's fine. It doesn't have to be, it doesn't have to necessarily be that academic format.
Yeah, and you said like a maximum of 50.
Yes. People are sending emails, and I'm just responding.
15 pages in content, so that doesn't include
Yes.
references and all that.
Yes.
And it's double space or single space?
Double space is,
Would it be bad to add pictures in there so you get the idea of what zoning area or land use map, like if we add that to the end of the.
you can, and you can add that. Again, it's a maximum of 15 pages of text.
Okay.
So if the
Text,
pictures
you
were
said.
1,000 words, and I
So, if we include site plans and stuff like that, it's within the 15 pages?
No.
And last but not least, do we connect it to development, how the zoning will change the value of the land and the venture? So do we do a pro forma in addition to? Or just zoning?
You can, but the bulk of the work needs to be about the land use regulation aspect.
Within the context of this
Specific
course.
things.
So financial analysis is not within the context. She doesn't even like how it's.
I mean, I think it's interesting in the context of this course, if different regulatory scenarios substantially change the value, because then you're talking about the regulatory scenarios. You're illustrating how different regulatory structures would affect the value. That's okay, but you need to do the work on the regulatory side of it.
Right, but the central idea is the reason you're doing the rezoning is to add.
I mean, that's true of all of these entitlements, right? You want to increase the value of the land. That's going to always be true.
that's why I wanted to know how deep into that aspect. Not much.
It has to
You
be,
can't qualitatively demonstrate it.
it has to be, it has to derive from an analysis of the land use regulation. That's all I'm saying.
You should be able to qualitatively demonstrate that rather than drill down into numbers. Yeah. So you can say, your analysis, in my opinion, based on what I'm hearing, should say something like, with this rezoning, I came to see existing value of the property 4 or 5 times, rather than giving dollars. I would say if you did that analysis, include it in the back, not within the content, as an appendix or something like that. No. Well, you heard what he said. Can I include pictures? Because a picture is worth 1,000 words, he said. Well, even Trump said that needs to be an appendix D. He doesn't want you including excess worksheet on the content page. I gotta make time. I mean, that's, but at the same time, while I'm making time, I don't want to be wasting time. Like we had a group meeting the other day with guys. I spend an hour driving to the meeting and an hour driving back home. I'd rather spend that hour on my computer talking to guys.
Yeah. But also depends, because I had a meeting with the case study with Jeff. I released 2 hours done.
Last time, that same group.
It doesn't have to include video. A lot of Nova's courses are online. We don't have the opportunity for face-to-face. So we got to find a way to do the same thing. You know what I'm saying? So, and that's where I'm coming from.
Yeah.
But if there's a reversal component to it.
It's not essential, but
He said, yeah.
Good learning.
It's not a bad thing.
And it just gave you, like, you talk to him in a different perspective, like, look, I had this problem, let's put everything aside.
By the way, when they came home, he said, sure.
You must know your
20 years ago.
Well, it sounds like you worked them for a while now.
Yeah, I mean, or I have no idea how often they do these zonings. Pick a city, if they're, or look for their zoning. Their objectives.
What was
I'm
Gulf
sorry,
Stream? Was
but
Gulf
it's
Stream?
really interesting. Maybe you want to use this for the analogy, the payments.
Well, the other,
You can do your,
everything's more neat.
the case study, and there's a reason, there are criteria that are necessary to get a reason that you're interested. And I want you to go through the review of the city doing that analysis, so.
Is that racetrack project?
Sorry?
So they're going through our rezoning right now? I like taking big projects and they're public and you can learn something.
Tell me about it.
I'm sure you can. Yeah, you can.
That's fine, resolution.
Make sure that you have some way to narrow it. You should get it under review.
So you're comparing the area of residential with.
Like I said, there's been pushback in a lot of
Because
places.
it's decreasing the income, that means that they're gonna be lower performing wage versus.
You know, and density is not always the issue with PUDs. It's really, it's not always a density problem. Sometimes it is. I mean, sometimes it's a design issue that they want to design the project in a way that doesn't meet the dimensional standards.
All that, I mean,
I'll be taking
totally about
Okay. No.
You can beautify it. They no permiten PUDs. Make it into a streetscape.
This is the time of day when I'm so tired of my own voice. I can imagine how you feel.
Oh, we're enjoying your voice.
especially if you stay.
Non-conformities. We talked a little bit about this. It's usually people refer to as grandfathering. A feature of an existing development that complied with the code at the time it was constructed, but no longer complies because of an amendment to the code. It seems simple enough. It means it's grandfathered, right? It's allowed to exist, to continue to exist. There's a couple of details in that definition, though, that are worth paying attention to. So the feature that is the issue must have complied with the code at the time it was constructed. All right, so let's talk about the example of a setback. If a house is built in a residential area that now has 10-foot side setbacks, but the house only has a 5-foot setback, and the addition, and it was because of an addition to the house that was not permitted. Does the 5-foot setback condition, is that legally non-conforming? No, because it didn't comply with the code at the time it was built. So you can't ever make legal what you have built illegally.
But then, how did it get built?
They just did it, or
They didn't have inspectors at the time.
That's a good question.
Right.
people do it all the time, yeah.
Yeah, there was a situation, one of my neighbors at the time bought the home and the
rear end had a big freestanding garage, and it was not permitted, but we bought the house and changed it.
Yes.
And there was no kind of regulation taken down or anything. So at that time, I think the city did press him on that, and I think there was problems about it, but being that he purchased it with the, on the property already, I mean, how does that?
I mean, I'm not saying that it's impossible for you to get some sort of, you know, post-approval,
Relief.
some sort of relief, but it's to be legally non-conforming, it had to have been legal at the time it was built. Maybe he gets variance, maybe he has an engineer evaluate it and get a post-approval. You know, go in and get a building permit, pay double the fee because it was built without the permit in hand, and get approval as if it had been permitted properly, but you do it post.
I have a question. For example, in my case, the property we bought, the fence goes right, it was all the way to the lake. According to the new code, or I don't know, it's supposed to be, it's on the easement, like long, there is like 20 feet from the lake towards the house.
A lake maintenance easement.
So the fence, we pull them out, we shouldn't, because they said that if we're gonna get a new, like a permit, now it has to be 20 feet from, you know, before the lake. But if they wanna if it was a repair, then it wouldn't be a problem. So, okay.
Don't. I charge people money for that kind of stuff.
What if the nonconformity was inspected by a building inspector back in the old days, where maybe permitting procedures were not in place, but for them to occupy, a building inspector had to go out there and inspect it. He didn't put the tape on the setback, and he signed off on it.
You know, the facts can be messy, because it can be difficult to determine what the facts are, and it can be difficult to prove it, even if you think you know what they are. And honestly, cities don't go out and chase after these situations unless there's a code violation complaint, typically. But to be legally non-conforming, it had to have complied with the code at the time it was constructed. That can be difficult to determine, and it can be difficult to prove. And the cause of the nonconformity must be an amendment to the code. So let's think of some good examples to illustrate this again. First of all, that complied with the code at the time it was constructed. Someone could have had a carport that is 5 feet from the property line, and the code at the time may have allowed a carport to be 5 feet from the property line, but enclosed structures had to be 10 feet from the property line. And then later on, they enclose it. Okay, so the enclosed building 5 feet from the property line is illegal. The carport 5 feet from the property line would have been legal at the time it was built. See, it had to have been legal at the time that it was constructed. And an example of when the nonconformity must be caused by a change to the code. What's something I've encountered? Restriped parking. A commercial development can be approved, a site plan can be approved with a parking plan. And there's a requirement, let's say, in a large shopping center for 400 parking spaces. But over time, the owner or the property manager, they go in and they restripe the parking. And they eliminate a few 7-foot chunks of parking here and there because they want to put in a shopping cart corral or whatever reason. Or they have to redo the disabled parking and it causes a shift in a lot of other parking. But then they end up with 380 spaces instead of 400 spaces. Is that legally non-conforming?
No.
It is not legally. It is not. It is illegal non-conforming. Because the change that occurred wasn't because the code changed. it became non-conforming because they modified the site in a way that was inconsistent with the approved site plan.
So if something was already approved or permitted, then it's fine?
If it was approved, permitted, and built according to those approvals and never changed, then it's fine.
So in my
It's
case, it changed
non-conforming.
because I took off the fence, so that means it changed?
Maybe, that could be why. I don't know, those drainage districts with their lake maintenance easements are crazy. They're cranky. Drainage districts. So, I'm trying to think of other examples. So if the change occurred, and sometimes this happens with separation of parcels. If one side of a shopping center is sold and the other side is retained, there could be parcel size nonconformities. The two of them, as a combined site, they would have met all the dimensional requirements. But as separate sites, they no longer meet the dimensional requirements because of lot size or depth or separation. So it was not a change in the code that made the site become non-conforming. It was the subdivision by the property owner that caused the non-conformity. That's not a legal non-conformity. Now, usually you will find a solution, okay? But you don't have that grandfathered sprinkled fairy dust that you have with a legal non-conforming use. You're illegal. You gotta find another way to fix it. I'm trying to think of some other examples. But so you get what I mean? So non-conformity, we use the term it's grandfathered. But in the parlance of zoning, the question is it a legal nonconformity? And to be a legal nonconformity, it had to have complied with the code at the time it was constructed. And the change had to have occurred to the code, not some unpermitted change done to the property.
So in that parking scenario, if you are deficient in your lot counts, parking space counts, could you reduce the elevated parking to compensate?
If the code allows it. And parking is, again, as we talked about in the parking discussion, it's one of the ways in which properties become legally non-conforming. There was let's say it was a 4 space per 1,000 square feet at the time that the site was built, and now it's 6 or something like that. So you have insufficient parking. But as long as the site complies with the regulations in effect at the time it was approved, you can hold that legal non-conforming status. And we'll talk about why that's an important status. Yeah. Go ahead.
What if there's a approved permitted change, then a code change, like say for instance, with the closing in of the carport, making it to a bedroom or something, and then that permitted is done correct, but the code now changes some configuration of the carport. Does that then affect that bedroom?
No, if it was permitted, if it was pursuant to the code and properly permitted and built according to the approved plans at the time, it has that grandfather status, and you can continue to use it as it is. So an illegal nonconformity occurs when the nonconformity results from unpermitted changes made to the property rather than from changes to the code. And there is no entitlement to continue to occupy and use property with an illegal nonconformity. The answer is make it conform to the code that was in effect at the time it was built. Legal non-conforming property can generally continue to be used and occupied as it was originally approved. Sometimes there are exceptions to that at times for things that the community may find really offensive. They may adopt something called an amortization provision. So if it usually pertains to a use. I encountered it when I did litigation in my prior position with the county. I litigated against adult nightclubs for a while. I did. I was the smut buster. I was very, very young. I looked very young. I had really long, straight hair, made me look even younger. And I was dealing with all these old guys who were like former contractors who had become zoning inspectors. And I was very comfortable with all the terminology that I was using in terms of adult nightclub. I could talk about specified anatomical areas. I could talk about this stuff. It was like totally, it was just my, you know. And I would talk to the inspectors, and I would see their faces just flush red, and they would start looking at their feet. Because to them, I looked like their daughter, their niece, and I'm talking about, and I'm taking depositions at the nightclub, and there's posters around me, and it was just, so those were the good old days. But there were areas of the unincorporated area of the county at the time where those kind of uses had been permitted, and the county they were blighting the neighborhood, and they had to get rid of them, so they prohibited them. They were permitted to continue for a time, but there was an amortization term set for them. They had to be eliminated within 5 years or 7 years. And that allowed the business owner to recoup their investment, find a suitable site to relocate, which was usually in a warehouse district, and try to move on. I mean, they litigated over it anyway. But sometimes the grandfathering will have a time limit associated with it. It's called an amortization provision. The key element to determining if an amortization provision is legal is whether it gives the business a reasonable opportunity to recoup their investment and find an alternative site to locate. So it can generally continue to be used and occupied as it was originally approved, unless it's subject to one of these absolute bars with an amortization provision.
Can you explain in simple words what grandfather status is? Because I still don't.
It is just a term that, it's a colloquial term that people use for a legal nonconformity.
Oh, okay.
Legal nonconformity, grandfather. That you'll see them used interchangeably. And some women elected officials will say, no, then you have to say grandmother. Yeah. They insist on gender neutral language, grandparent provisions.
Is that coming, grandparent provision?
I know elected officials who would insist on that right now, women elected officials. Enlargement, so that the status as a legal nonconformity as opposed to an illegal nonconformity. Okay, that was all I had on that. So only we got that. Will become important when we talk about casualty. All right? If you're making an investment in an ongoing business, but it's sitting in a building that is a legally non-conforming building, or it is a use that is a legally non-conforming use, the question becomes, if something happens, if there is a casualty that wipes that business out, can I rebuild it in the same way? If it is a legal nonconformity, there will be rules about thresholds. If the destruction is 30%, 40%, generally you can. If it exceeds that threshold, generally you cannot. But if it's an illegal nonconformity, you get nothing. You can't rebuild it at all, no matter what the threshold is.
Where you can rebuild it, but in compliance with the new code.
In compliance with the new code, yeah.
Even if you had the amortization of this?
If it's an illegal non-conforming use, you have no protection.
If it was legal?
If it was legal, non-conforming, subject to an amortization, that would be a really interesting case to find out if there's 2 years left on the amortization and there's a casualty, would they allow you to rebuild? And would you get the full period of amortization at that point? That would be a very interesting fight I would like to have as a lawyer.
You mean the 2 years left?
Right. If it's a 7-year amortization and you have a casualty when there's 2 years left, what do you get to rebuild? And do you get the remaining 2 years, or do you get 7? What an interesting case that would be. I could write a legal drama for TV based on that. I know, it's not very exciting. I'm making fun of myself. That's my idea of high drama.
But in terms of value of the building, considering you only have 2 years, possibly 2 years left under that provision, unless you're building on a pocket, would be worthwhile return on investment to go build again on that site.
Is it financially feasible?
Feasible,
to do that?
Right. I mean, those are the questions. If I was representing the owner of that business, I would make the argument that I get to rebuild and I get another 7 years. Thank you very much. And that's the argument I would make. Because you determined, local government, that 7 years is a reasonable time for me to recoup my investment. I don't know. It would be a fun, that's what I'm saying, it would be a fun discussion. I know, not fun, okay. I'm such a nerd. But that status is important. If it's not, and sometimes it's only important to a lender. Again, we talked about that. I've done zoning diligence for a national lender who, of all the things that they lend money on, it's mobile home parks. And I would find myself looking and saying, why do you care so much about the casualty? You could put this land to much better use if you had to foreclose. All they want to know is that they get to put all the mobile homes back because the mobile homes are cash-generating businesses. So they underwrite the loan for that specific use. And if you can't get a zoning lawyer to tell them that they can replace that use, they're not going to issue the loan.
That scenario with the building that is non-conforming, and if the casualty is 100%, are there a case history as to whether or not the insurance company in a non-conforming situation would provide relief to that owner in terms of 100% compensation from insurability?
I mean, the insurance decision is going to be a matter of the insurance coverage and the value. What you do with the money, as long as you're not committing fraud, whether you build a mobile home park or a multifamily residential with the proceeds of the insurance, I'm not sure that the insurance company will care.
So they would not compel you to rebuild, that you can do whatever you want to do?
You know, unless the terms, and I'm not an insurance expert, unless the terms of the insurance require you to use the proceeds to build exactly what was insured, otherwise it's fraud, and I don't know if that's what property insurance typically provides.
Well, I can answer that because when your grandfather did and it burns down, when you build it again, it has to be built under the new standards. Even if it's 30, normally the guidelines are about it's 30% or more destroyed. I mean, if you did up
They
to
vary
30%,
from,
something like
they
that,
tend to vary
varies.
from 30 to 50%. I've seen some as high as 75%.
Right, so you buy additional insurance for a change of ordinance, and in my case, I had to purchase a very big one because I knew that the building is not conforming. In addition, if it stays closed, there's other things. If it stays closed for 90 days while you're renovating,
You get business interruption.
you're no longer grandfathered in unless you ask for a special.
And
So there's different cities, different rules.
if the nonconformity, and there can be nonconformities related to every aspect of the site. You can have a nonconforming use, no matter what box it's sitting in. The use, that was the adult nightclub scenario that I talked about. The use was no longer permitted. Didn't matter what type of building you put it in. I know, now you're all looking embarrassed.
So what happened? Did they have to relocate? Were they none of the business anymore, or?
The one that I litigated the longest, I won at trial, and the situation was a separation. The adult nightclub was too close to a residential area and too close to churches. And they alleged that they had a constitutional right, that was a constitutionally protected use because of expressive activity. I'm being serious. Exotic dancing is constitutionally protected expression. So we won at trial, they appealed, I argued it in the 11th Circuit Court of Appeals, we won it at the appellate level. They tried to get the Supreme Court to take the case. There was another case that the Supreme Court decided in about the same time frame that was about adult nightclubs. So the court had us brief the court on the effect of that case, but still never did take jurisdiction of the case. So I filed a brief in the Supreme Court opposing the court taking the case, and then I filed a brief saying why this other decision didn't create a conflict that should require them to take the case, because I won below. I didn't want them to take the case. And eventually, after all of that, the only thing that closed the adult nightclub was a RICO investigation, federal criminal investigation against the owner. I prevailed at every step, and I was completely ineffective at closing the adult nightclub. It took the feds to close the adult nightclub.
We had a case in the first class where Brickyard, remember that case
Yep.
with Brickyard, and the community developed a residential
Around it,
around it, so the Brickyard would be non-conforming, right?
yes.
I'm trying to remember if they were given some relief to have them relocate, or they had to just move out because.
I don't remember either, and I'll probably look back at the facts of that too to remind myself. That may have been a situation where they were required to close down within a period of time, an amortization provision.
Good.
And you can not just, sassy, amusing adult nightclub cases, but you can encounter this with what other kinds of uses? Smoke shops,
Funeral home with the cremation.
yes, something like pill mills have gone through, the zoning has been clamping down on pill mills. You know what I mean, the doctors who ostensibly distribute pain medication.
Pain clinics, yeah.
Yeah, pain clinics.
So did you have to do?
Wasn't there doctor shopping where they go to different?
Yeah, so
clinics?
there's a public policy concern, and so they clamp down on the zoning of those kinds of doctors' offices to try to control them. But there may have been amortization provisions on those. I'm not sure. I didn't look at any of those.
So the Fifth Amendment says you must compensate. So there are cases where they took the nightclub and did not have to compensate.
Well, that's why local governments use amortization provisions. If you give them a period of time to recoup their investment in, they don't typically own the land and the building. They're a tenant, and they've made an investment in FF&E or something like that,
Okay.
or they have their lease is 5 years. So you give them an opportunity so you don't take it, because you give them a chance to work it out with that, in a market setting without having to take it. If you said that's it, tomorrow you're closed down, that could be a taking. That could be a taking. Okay, so there are reasons why it can be very important to figure out if the property is legally non-conforming, if it's illegally non-conforming, and what you can do, what you might have to do to fix it in the case of casualty. Now, if it is legally non-conforming, there are constraints not just on the percentage of casualty before you trigger the application of the new code, but enlargement and modification also. So if you have a legally non-conforming use and you want to enlarge it, there are typically limitations on how much you can enlarge it and what code will apply to the enlargement. Oftentimes you can enlarge it as much as you want as long as the expansion is compliant with the code. Sometimes you can enlarge it by a percentage, even though, and use the same setbacks as applied to the rest of the project, even though they would be non-conforming if it's a small enlargement by percentage. So you have to, it's like a word puzzle. I don't know if you were good at, I wasn't good at real math. I wasn't particularly that much better at word problems. Maybe I was better at word problems, but you have to work through it. You have to look step by step through the regulations and figure out where your facts fall, or work with your lawyer to do it. So that's the key with nonconformities.
With the exception, though, on a legal building would be ADA.
Would be what?
ADA rules.
Yeah. I've had problems where the parking was changed in order to accommodate handicap spaces, and then it caused the parking to become non-conforming, and the city would issue a violation for the non-conforming parking, even though the cause of the non-conforming parking was the installation of ADA. They've reconciled those in most places now, but I've had to deal with some irreconcilable differences. So the property owner was being sued because they didn't have handicap spaces in the right location or enough of them. So they settle and they agree to put the handicap spaces in the right location and enough of them, and that causes them to lose 5 spaces overall, and the next thing you know, they get a code violation for losing the 5 spaces.
So would that be a variance for a hardship?
Usually, there can be a different, you might have to get a variance, but there might be a provision of the code that allows minor waivers to accommodate ADA regulations specifically. It happened enough to where the city codes have been generally adjusted to allow them to accommodate anything that's necessary to make the site compliant with the ADA.
Well, it's beyond ADA, there's a lawsuit as well, so would that lawsuit not trump anything else if you're being compelled by the outcome of the lawsuit?
I mean, it's a good argument to the city not to pursue the code violation, but sometimes they can be very unsympathetic. They can be, well, the ADA's been around since 1990, whatever, and you've repaved this parking lot 3 different times. You could have fixed this with a permit. You didn't have to wait. You didn't have to do it without a permit because you were being sued, and now come ask us to, you know. They can be a little cranky sometimes about it. But most of the time, if the only change, or if the change that is generating the code violation was to accommodate some sort of ADA compliance, there's usually not going to be, they'll resolve it. But they're going to have to resolve it.
Question. Thinking in terms of an obligation, so you're an attorney dealing with these type of questions. Mary J., a developer looking at a piece of land for a particular purpose, will come to you before the closing of acquiring the land. How much time is a reasonable time to give you to say, to do this research to see if the zoning and whatever entitlements can be obtained? The due diligence period. What length of time is reasonable for a due diligence research?
It can vary a lot. I've done them in a couple of days. It's taken weeks at times when I needed a lot of documents from the public, from the city, and I couldn't get them to respond. So a lot of the more information that becomes available online, the quicker that we turn those diligence reports around. But clients are spoiled now. And sometimes I'm like, no, you don't understand. This is in the middle of Lee County, Florida. They don't even have computers plugged in there. It's like, I've got to send someone to go knock on the door of the city clerk's office and ask for these records. It's like the olden days. So it can vary, but it's usually dependent on the amount of information that's available online versus it has to be obtained through the city or the county or whoever the local government is.
So you do a lot of due diligence for commercial properties. Do you advise your clients, is there a figure of how much their change of ordinance insurance should be, should they buy the property moving forward?
If there's a lawyer who does that, it's not me. That's not part of what I would do for a client as a land use lawyer. No. Don't know. Okay. Okay. More down in the dirt, subdivision. Subdivision regulations tend to be another section of the code. They're usually not in the zoning code. There's usually a subdivision code. It's considered to be part of the land development regulations that are required to implement the comprehensive plan, but it's very often a separate little part of the book. Subdivision regulations derive from Chapter 177 of the Florida statutes, and which sets minimum standards for plats to be recorded in the public records. So in a very simple level, all that a plat is an accurate drawing of the land prepared by a surveyor. The surveyor has to be certified as a surveyor and licensed and all of that. And it needs to, there are degrees of accuracy that surveyor has to comply with in order to seal and certify a plat as a correct and accurate representation of the land. Typically in the kind of subdivision we were talking about before in the context of vested rights or where a subdivision becomes substandard, that's the most common kind of subdivision that we're aware of. A big block of formerly rangeland, agricultural land, vacant land gets subdivided into lots and blocks for single-family homes. But any parcel can be platted simply by preparing a new plat that meets the standards of the statute and the local ordinance for accuracy. And part of the reason local governments need to approve plats, there was a time when, as long as a surveyor who was licensed prepared the plat, it could be recorded. And there was no local government involvement at all, because all it is a description of the land. But now local governments have to approve the plats before they can be recorded, and this has been the case for a very long time. And the reason local governments become involved is to ensure that the subdivision meets all these standards. That the lots have access to a public street, that the streets and other public facilities and easements that are needed to provide public service to the individual lots are shown on the plat, and that they're dedicated to the public. They meet the minimum requirements for those easements and those streets. So a developer or a subdivider, who wants to sell off lots might want to put in, 10-foot streets, but the city code requires, what's a typical 2-lane street section?
24 feet.
24? Okay. So they want to put in essentially driveways instead of streets. But the city government reviews the plat and must approve it to ensure that the streets meet the standards for a safe 2-lane street. And that easements are dedicated to put in water, sewer, drainage, so on.
Sidewalks.
Mm-hmm.
Are parcels, tracts, folios, that such the same thing?
The term folio or tax parcel is just that. It's a word developed to describe land, a parcel of land for tax purposes. A parcel is a generic term. Tract, lot, and block tends to be the terminology that is used on the plat, to say it's the Tracy plat, and it's Plat Book 1, page 1 of the land of Tracy. And it's broken into 6 blocks, or let's say 2 tracts, 6 blocks, and multiple lots. So surveyors tend to use the terms tract, block, and lot to break down a large piece of land. But the term parcel can be used generically. It's not really a term of art. But tax parcel means a single parcel of land that's being taxed as one, as one parcel or folio. The folio is the description of a tax parcel generally. So what you encounter with subdivision regulations can vary a great deal from one local government to another. Some local governments are very strict, and any subdivision of land requires a replat. If you're breaking one parcel into 2, you need to file a new plat. Some of them don't require that. They say 3 or 5 or something, and they'll allow you to do something like an informal lot split that doesn't involve a full plat, to do something less. Some local governments conduct no substantive regulation other than streets and utility easements. Yeah.
So being that local governments are not involved under the planning of the subdivisions, to ensure that they have the access to public streets and infrastructure certainly, does that also include like sidewalks, or is that more of zoning? And does the public streets and all that also tie into zoning, or is that just a regulation for planning?
They tend to work together. You tend to find that an engineering department handles the subdivision and the zoning or planning department handles the site plan, but they work together. The subdivision regulations can cover not just the designation of land for sidewalks, but the actual construction of sidewalks. They can trigger those actual construction requirements as conditions of the plat. And they can require a developer to post security for those kind of improvements that were made a condition of the plat. So it can be simply drawing areas on the plat to ensure that there is room to place the public facilities, or it can be build the public facilities and give us a bond to make sure you're going to do it. And other local governments use the platting process as a means to regulate even further. Like in Broward County, pursuant to the Broward County Charter, the county was not the local government for, for land within the cities, but they had the power to approve plats countywide. So they used that power to insinuate themselves into the development approval process of the cities. That would have normally just been done by the cities on their own, but the county has countywide plat approval authority. So they adopted a land development code that imposes a lot of requirements on the plat process. But it's more common that the subdivision process is simply the accurate description of the land combined with the reservation and dedication of lands needed for the public facilities, combined with security to construct certain public facilities like utilities and sidewalks. That's the common thing. And the most, the sort of basic level of land use control before you go with our friend down there as a general contractor to apply for a building permit is the site plan approval. And that's, they can be called a lot of different things. Site development plans, major development plans, minor development plans, site development plans, oh, I already said that. Sometimes there's a threshold development level that you have to hit in terms of square footage or number of units before the city will require that you go through a site plan approval process. Sometimes if you do a full-blown lot and block plat, you don't have to do the site plan because they have, I think this is true in the city of Weston. If you go through a single-family subdivision all the way down to lots and blocks, they don't make you do a site plan. They torture you sufficiently with the subdivision plat and don't make you do it all again in the context of a site plan. So these can be very, very, very detailed. It starts to make you feel, as a development team, like you're doing building plans. They get so detailed. There was a time when a site plan was a single sheet and not a lot else, and it showed the general layout of your project, and there might be a data table, but now most cities require pretty well-developed engineering plans, site lighting plans, tree relocation, tree disposition charts, landscape plans, and all of these things. So and then you have to go, essentially you take those once they're approved and convert them into building plans. And that step is smaller than it used to be, but the site plan is much more burdensome than it used to be.
So in Weston's example, you said that if you go through the process of subdividing and planning, you don't have to go through the site plan approval process?
That's my recollection from a project where I worked on the plat in Weston.
So
You'll have to site plan the entranceway, like the entrance feature and things like that, but you don't have to site plan the lots and the roads as long as you have them depicted on the plat.
who regulates them, like the setbacks?
That would be the individual building permit for the home. So, and I'm talking about a scenario where a developer would do the subdivision plat and then sell pods to a builder or individual lots to a homeowner to have a custom home built, and those homes would have to comply with the building permit plans for the individual lot development would have to comply with the setbacks. All right, let's go back to Fort Lauderdale and look at a little bit of what's required in a site plan application. Next week I have to do a site plan level 3 application.
When you say
say application, you mean what you submit with your site plan?
Yes.
For approval?
Yeah. I'm trying to think, maybe the website would be application that shows better.
Of all the architects and engineers, who's the one that does the site plan?
Usually the architect does the same. Usually.
With engineering input for structural details.
Yeah, and that's what I'm saying. In more and more cities, you're gonna have to do at least conceptual paving and drainage plans,
Right.
conceptual engineering plans.
Right.
Where'd that come from?
Question.
Which tab do you click on when you go to municode.com to get to all of that?
She's in the city. She
You
went
go to
back the city.
municode.com and then you check the state that you want to look in, and then it lists all the cities that they provide codes for, and you go down to the city.
Are those codes, the comprehensive plan, or is it codes for everything?
It's the code of ordinances,
Oh, okay.
so
Code
it would be
library?
the zoning
Yeah,
code and the
and
other
go
land
forward.
development
Oh,
regulations,
that
but
code
not
library,
necessarily
got
the
it, got it.
comprehensive plan.
So in order for you to get a how do you request, you just call the city, like
To get the comprehensive
is
plan,
it on the website?
look on the website for the comprehensive plan, or whatever they call it. In Miami-Dade County, they call it the master development plan, I think. So here are some applications. So we're gonna see a list here of what you have to have. Bless you. Okay, an application, proof of ownership, a letter, a traffic study for projects that cross a threshold, photographs of the property and all the surrounding properties, a narrative, and these are all the sheets that will be in the site plan application plan set. Zoning and land use maps, current survey, the most recorded plat, an aerial photo, plans, a site plan, details of the site plan, floor plans of all the buildings, building elevations, renderings, landscape plans, photometric design, and engineering plans. That's a lot of detail for something that you're just asking for the first, what do you think about this? kind of approval. It's a lot of money to put in to start getting feedback from the city. You can do pre-application meetings with all these city staff so that if you're gonna get blown out of the water, so that you can get your project closer to this before you start actually spending money on it. But this is what it takes to walk in the door and start the process to get a site plan approved. And then there are many sets of these. So, and then what happens is these plans and all of the supporting documents that are turned in for a project, they get reviewed by the different agencies in the city. The engineer, the surveyor, the landscape reviewer, the building department, the fire department, the police department, the planners, they all review it against the code and the rules that they're charged to enforce, and they prepare a report of comments. And that's what you have to start correcting on the plans, resubmit, and then you move on to the next step. So and Fort Lauderdale is a good example. They call that staff review, they call it development review committee. From DRC, you go to the planning and zoning board. Certain projects become finally approved at the planning and zoning board, some of them go on to the city commission. And at each step, you could be required to make changes. And then after it's all approved, you go back to the staff and they confirm that you've made all of the changes that have been required and that you're providing them with everything that's necessary to meet the conditions before you can go down the hall to the building department and apply for building permits.
On average, how long does this process take with the city of Fort Lauderdale?
I mean, it will depend on the size and the type of the project. It can take, so you have to apply about 5 weeks before you get a meeting, and then you attend a meeting, and then you take as long as you take to address the comments, and it can take about another 6 weeks to get onto a planning and zoning board agenda, and sometimes you end up getting deferred. And if you're final at planning and zoning, so it can take as little as 4 months, but that's pretty tight. It's pretty tight. Sometimes they can't, Fort Lauderdale's not like this, but some of the cities, they can't get a quorum. So you lose a month because they can't get the advisory board together. You can't get a quorum to have a meeting. Ugh. Frustrating. And now, an aspect that we encounter much more often now than we used to, is a mandatory community meeting requirement. They've always required, the city of Fort Lauderdale and others, have always required public notices. You'll typically have to mail or pay the city to mail letters to the surrounding property owners about your proposed project, post signs, maybe put an ad in the newspaper. That's been in existence for a long time. But now they're going the extra step of requiring that you go and notify the civic associations in the vicinity of your project and have a meeting with them, a public meeting where they can complain about your project and tell you what they want changed. And it's a way of the elected officials sort of flushing out some of those objections before it gets to a public hearing. So, but you have to look at it from a development perspective as an opportunity to get it right, okay? It can be very frustrating that your project can be whiptailed around by a single resident that decides to show up and object. But at least if you have a meeting with them in advance, in an informal setting, you get to hear what the objection is. You get to figure out what's really behind it, and you try to address it. It might be something very simple, and it might be as simple as they understanding that you're going to listen to them and that you're going to try your best, and you're going to try to make the project high quality, and you're going to try to make it work for them. So sometimes it's really valuable to go through that community process. The flip side of it is that more and more often city commissioners will not approve when these objectors show up. They just won't. So it can be, this is the era of the neighborhood objector. They have a lot of power in the process right now. That is that set of slides.
Is staff generally open to meetings beforehand to go over some of these
Yes.
issues?
Yes.
Are they open to that?
Yes,
Okay.
they are.
I mean, even for a small act?
Yes.
That's part of the service.
The city manager is again?
Well, you know, you want to, I think you want to right size. You want to go to the right level. You don't necessarily want to get a meeting with the city manager for your 4-unit development. It's probably not necessary, and it might just irritate the city manager. They might meet with you, but you want to go to the right level. The folks that know their code and they're going to perform the first level of review for you, they see all the projects come through. So they know what's working right now and what isn't. They know what's triggering opposition and what isn't. You know, and you hear important things. It's like sometimes their code doesn't say yet that they want street trees because they want to provide shade for pedestrian areas, and maybe the code hasn't caught up yet. So you could in theory not be responsible to comply with that. But if they tell you that that's a big issue right now and you can accommodate it, the sooner you build it into your design, the better. Even if it's in excess of the minimum requirements of the code, the sooner you learn, the better able you are to design your project to minimize the conflict. Because again, time is money. the faster you can get through the process, the more likely your project is to be successful. You've obviously done marketing studies, you think there's a market for your project, but you have to catch the cycle. If you get hung up in permitting for an extra 18 months, you could lose the cycle. So time is money, and sometimes it pays to just give them what they want. I have the next set of slides.
So basically, the person to speak to is the head of the planning and zoning department in a private conversation?
You can ask for a meeting. Sometimes you figure out who is the lead planner for the intake of site plans. That's probably where I would start. They can have different names, they can have different titles. Sometimes they'll have professional courtesy days, or what they call pre-application meeting days. Professional courtesy days are just to do that, and it'll work with building plans too, where you come in, but you're not really submitting, but you're coming in to show them a plan or an issue that you might have a concern with, and then they'll walk through it with you. And most cities have a pre-application process that you can have a meeting where you show them the generally what your project is, you know, where it is, what you're planning to do, and they give you a heads up about what the hot button issues are for that.
What I've found is that normally the planners are regionalized. They serve certain regions, and I normally try and find out who's in charge of this region and go directly to them.
Yeah.
And that's my issue. Do I go to the head of the staff that puts together the staff recommendation reports, or the engineer? So who's the right person to click it?
You know, with a site plan, I would start with the head of the department that processes the site plan. And if you don't get a call back, or you get someone on the phone and you tell them what you'd like to talk about, they can usually direct you to the right person. No, we've got senior planners who do that, and she takes care of the south region, and he takes care of the north region, and you're in the north, so I'm going to put your phone call through to him. You know, they're pretty cooperative, and they want to get you to the right person, because nobody really wants to waste their time having a meeting on something that's not within their job responsibilities.
So what percentage of your job is spent in politics?
All land development is political. It's all political. There's political implications associated with every step of this process. It doesn't all rise to the level of someone needs to make a contribution in order for a quid pro quo. You don't do that. That's not what it's about. But the political considerations that I'm talking about are, what are the concerns of the community? That's what the politicians are there to take care of. So how the community is formed and structured through land development is essentially always going to be a local political issue. Trying to think where we are before I get on to the next. This was a lot of material. Give me 5 minutes and let me evaluate whether I'm going to go on to more material, or I'm going to stop the new material here for the purpose of the midterm. Did you have a question?
Let me with our groups for a little bit.
Yep. Could you use some time to meet with your groups to work on your case studies?
Yes.
Yes? Yes. Okay. Work on your case studies, and let me resolve whether I'm going to add any more material right now.
I also have a question on your project with the adults dancing. Did you have to do field research?
The inspectors did, and that's what would make them embarrassed, because I would ask them, and did you observe specified anatomical areas? And they would laugh, and they would turn red in the face. But I did have to do document review at offices of the adult nightclub owner, and that's where I was surrounded by these crazy posters.
So you actually were in there yourself?
Yeah. Well, no, it was their offices right outside. I didn't go to one.
Okay. Excuse me, gentlemen.
And it's been through rezoning for some, or land use amendment.
What are you saying?
Yeah, well, that's a trendy name.
You wanna read through this and put some
I think that we have to workers, we live here too. Of course, right now, we can get a put it in the property official, and he's gonna
There's a whole package where you want to tell us which one part is more comfortable.
What do you think?
You can do the bigger project if you can manage it, or you can focus on a project within it if you don't want to.
I just want to get in there.
I was talking to him about it.
I think we have
No, I just gotta work for case study again. Yeah, there's land use plan amendment, but there was a criteria to require that there be a conceptual site plan. Is there a conceptual site plan?
Are they changing, you know, you see the colors of the green?
Yeah, I guess it's similar to that. They make it a little bit easier. We were talking, we were just trying to talk about suburbs instead of.
I'm gonna cover my end, I can't cover all. So as long as, you know what I mean?
No, same thing at the house.
I'm confident I can speak for
This,
this.
what's
45 seconds. As long as it all comes together as one voice.
Huh?
All right.
It's been around.
You agree? My
I think it looks
charged,
similar to the regular.
let's, I'm gonna switch on the
I grew to add something.
That's temporary, but for everything you wrote,
That's 10 out of
Yes, sir?
But I guess when you start out, talk about should we do like a background and that's why
We know,
I'm gonna read comments.
We wrote down two actions.
Applications on it where it is.
Do you mind if I get you? No, this is for the actual.
Basically, just give a hospital, the tree colors, like the
Oh, like you mean like an intro for the entire project?
are you guys doing the,
This way, 240 million.
See, that's what we're doing. We see a home. I think we should go, like, we should do like a simple house. Do a 4-story partition, like,
haven't found the records of the
to get to the final one. Yeah.
I mean, what interests y'all? I don't know.
In the staff report say the applicant seeks to move from this to that. And are there conceptual plans or pictures that consultant that worked on the project.
Yeah. Like the main points on this so like the meeting started.
Not asking for their files or anything, but you understand that they worked on the project, that all you're looking for is most direction, how to get from access to the
But I think this is kind of like a motion that's on back of our residential development or even if it's service in the community. We're not, do you see what we're at?
There's levels that are conforming below that.
Again, if they just come up locally, they'll be willing to give you enough time to say, contact this planner. Yeah. And again, if you give me land, they don't have to do this kind of stuff to become.
Yeah, then I was going to like site.
So they have to certain facilities that they had to do, right? So they probably had to do similar research when they were in their master's program to get their AIC.
I mean, I'm going by this and start looking like, you don't need to address. Because they're located.
So patient, and it's
Yeah, yeah. But do you think it would be broad?
I would appreciate it so much. I know you might need to, come back to me, maybe you can't do it right now, you know, the time to call, right? So you do it all the time. That's it, exactly. If you deal with traditional systems, you know exactly what it is. Exactly.
So I have to shave and color. They got so much stuff and zone them HD and yeah, we have.
I'm just sitting down because
Yeah,
my back hurts when I stand up.
yeah. Anything you can have a little index.
So then what's the point?
No, that's how it's
What I should do is, they used to, in the other classrooms, they used to have science rules with maps and science and everything that was sent out.
I'm curious. I used to go back to they went out to the dogs and put a hospital.
Just now convincing me that they're very
on the corner of
to
Carnegie.
go on to the next step. So it's like college students.
I mean, that's like the actual closer to 75. Other side of the road and more, or should I just say located?
Here's the ordinance.
do
This is
develop.
how it evolves, and it's making sense.
Well, what,
This is some of the.
Everyone knows.
Half of the, she was hired by South.
do you have the records that you have here?
Yeah, the minutes is from page 90.
That there was a zone change application and it was.
This is a letter, and you'll see,
So
one of it is addressing all their comments.
there should be a staff report associated with that. Lays out the criteria
It's on the
Where
rezoning.
this is like a 10-year extension. And his neighbors were saying,
Yeah, but that's what they try to put on, because the, image with
"Will you
the.
tell us everything we're gonna be doing in the future, instead of just piecemealing this, you know, since 1950? And 92 rules, no file rules. Well, what's next?
It looks really strong.
Pembroke Pines can be difficult to
And it
get
just
out
spells
of,
out
they
the
don't put as
whole
much on their
city,
websites as some cities.
and it addressed to the concrete. They're saying, this is everything we're ever gonna do. We'll tell you everything right now. We'll show you everything.
So,
And it helps the project.
and there's probably, might be able to call, Mike's,
This online. As criteria 1, 2, 3, 4, 5, 6. One slide. You like that? Yeah.
and they might say, we
Yes.
can't.
Let's break our.
City clerk's office.
Okay. Agreed.
Yeah, that's what I mean. They've all.
So each one of us picks a section and practices their 35 seconds.
So you might try Mike's. I think before senior.
As long as you know your name.
Planners.
That should have the conversation. Just be careful, you guys add the shot where you go with it. Maybe you're wrong.
No, so, and again, if some kids are what's concerning, you can say, I'm a student in a master's program, I'm going to use this project.
No, no.